gentlemen, the American Jury and Bulldog Nation, I don't do this very often, but you should consider this a lecture, and I don't know how long it's going to go. In addition to that, we plan to break out the sections of the Constitution as well as the Bill of Rights. I want all of you to know that I have done no study preparation for what I'm about to do. I am going to do it all off the top of my head, with the exception of using an outline for sections of the Constitution, and then I'm actually going to read each Bill of Rights, each amendment to the Constitution, which I want to speak about. But I first want to give a little bit of backdrop and background, very briefly. The Declaration of Independence, as we all know, was ratified in 1776. It was proposed on July the 2nd, and then it was voted upon on July 4th, and then it was later signed all the way in August. But we celebrated on July 4th, and that took place in 1776. And that was the gathering of the Second Continental Congress. The First Continental Congress had gathered a year before. So we had the Declaration of Independence, and we fought the British under the guise of the Declaration of Independence, and we formed what's called the Articles of Confederation. From 1776 all the way up until the Constitution, which was voted upon in 1787, ratified in 1787, that was in fact the government that we used. And the Articles of Confederation were not very good. They did not have all of the things that we now have under our Constitution. There was currency issues. Each state had their own currency. There was problems with commerce. It didn't work very well. So our founding fathers knew that it was time to create a government, and what came out of the next convention that they had relative to that was the Constitution of 1787. It was, in fact, the creation of our government. And I'm going to explain that very briefly of what's in the Constitution. By the way, this lecture is meant for beginners. It is not meant to be sophisticated for all of you constitutionalists, professors out there, if you would. This is meant to be for the average Jane and Joe citizen of the United States. And I think I will do it very, very well. First off, the Constitution has a little preamble, and then it has what's called Article 1. And Article 1 covers the legislature. It was first. And what the Constitution covered was the Congress, the House, and the Senate. That's what Article 1 set up. And what Article 1 allows is for Congress to, all the revenue bills, and you hear this all the time, the revenue bills originate in the House. And then Section 8 of Article 1 spells out all the many powers that the legislature has. And those are the powers that you're familiar with now. You hear them debated all the time. I'm going to choose not to go through each of them. Then you have what's called Article 2 of the Constitution. And Article 2 of the Constitution sets up the President of the United States, the Vice Presidency, and it lays out that the President will be, in fact, the Commander-in-Chief of the military, that he has the power to submit treaties and approve treaties with the consent of the Senate. There's a great funny story in history where George Washington went over to Congress to get a treaty approved, and he thought it'd be like wham bam, thank you ma'am, and they deliberated, and he got pissed off and left. I mean, just imagine, that'd be a great scene in a movie, wouldn't it? George Washington sitting outside the hallway waiting for Congress to approve the treaty. And then also he has the authority to appoint ambassadors to foreign countries. Then we have what's called Article 3, and you've heard of this many times in the news. They'll call Article 3 judges. Well, Article 3 judges are considered the federal judges, and of course Article 3 laid out the creation of the United States Supreme Court. By the way, the first Supreme Court Chief Justice was John Jay. And remember, when the Constitution the battle to ratify the Constitution was led by the Federalist Papers, which were primarily written by foremost Alexander Hamilton, James Madison, and a few by John Jay. John Jay would become the first Chief Justice of the U.S. Supreme Court. I also want to point out that relative to the Supreme Court, the third Chief Justice of the Supreme Court, John Marshall, who served for a very long time, he laid out in a famous Supreme Court decision, Marbury versus Madison, that the Supreme Court was the final decider of what was constitutional and what was not constitutional. That wasn't set up in the Constitution. And just to let you know, the Constitution isn't very long. So what has come out of the Supreme Court decisions is all of these additional constitutional findings and workings that weren't there in the original paper. When you hear people say we need original constitutional Supreme Court judges and federal judges, what they're really saying is they want somebody who just sees the Constitution, the Bill of Rights, what does it say, and deal with it. Well, what's happened is, of course, there's been a lot of rights that have come out of that. Some make common sense, some not so much. For example, the right to life issue, where they found abortion in the right to privacy, which doesn't exist in the Constitution anywhere. However, it does make sense in a way, by the way, not for abortion, that we would have the right to privacy. All right, Article 4 of the Constitution lays out that the United States has the full faith and credit responsibilities of the United States, anything that they do relative to monetary policy, that the citizens of each state have the rights of being a citizen in every state. We kind of take that for granted, but isn't it interesting? If we Kentuckians go to Ohio, we have the same rights as any Ohioans, vice versa. But we take that for granted, but I think that's interesting that they put that in there, that they wanted this free flow between the states of citizens. Section 4 of Article 4 sets forth that, and this is really relevant to today, it's why I'm using it, says that the federal government shall protect the states from invasion. Now, I personally do not understand any way, shape, or form how you cannot argue that there is an invasion in this country going on in its southern border. If you look up the definition of invasion, I think it most certainly applies. So I believe that there should be some type of action taken place against the President of the United States and Congress for their failure to protect us from the invasion on our southern border. Article 5 deals with the amendments and how the amendments have to take place. We have not had a new amendment, I think, since the 1970s. Article 6 is the debts and whatever the debts that are valid, that we're responsible for. They called it engagements. That's contracts. So the government is allowed to incur debt and also enter into contracts. Then Article 7, the ratification of the Constitution had to be 9 of 13 states. And that is what the Federalists and what were called the Anti-Federalists. The Federalists, which, this is very interesting, the Federalists, which were led by Hamilton in the early part of our country, believed in a strong central government. They believed in a strong bank, central bank. They believed in a very powerful central government. George Washington, our first president, serving 2 terms, would actually adopt that point of view as well. James Madison, who helped pass the Constitution, and by the way, he is considered the author of the Constitution, he would break off from Adams and lead, along with Jefferson, what were referred to as the Anti-Federalists. They believed in a more agrarian economy, less central power, more power to the states. Now, I want everyone to know, and I find this also very interesting, is when there was the ratification of the Constitution going on, one of the biggest opponents of the Constitution being ratified was Patrick Henry of Virginia. I read a biography of him. I've read many biographies of him, but one was called The Voice of Thunder. That was kind of his nickname. I always get a kick out of the fact that Patrick Henry was feared by the other founding fathers. That's hard to think about how we glorified George Washington, Jefferson, Adams, Franklin, all of them. Well, guess what? They all were scared to hell out of Patrick Henry. By the way, George Washington, also from Virginia, offered Henry many jobs with the federal government. He turned them all down. He didn't want to be Secretary of State. He didn't want to be a Supreme Court justice. Patrick Henry would be the first governor of Virginia, and he would serve as governor of Virginia many times. But Patrick Henry made a famous line. He said, "I smell a rat," when it came to the Constitution. And thanks to Patrick Henry, we have what's called a Bill of Rights. Now, I look at the Bill of Rights really and the amendments as a separate document. It's funny, so often I see on social media somebody will say, "I don't know why you say it's two documents, it's one document." Well, it was in fact created several years later, 2 years later, when it was adopted. So in 1789, the Constitution was submitted to the states, and in 1791, the first 10 amendments were ratified, and they would be called what's called the Bill of Rights. And I'm now going to go through each one of these 27 amendments and explain what they are and give my 2 cents worth. But I think it'll be fun. All right, as I go through each of these, I want to read them, and then I want to make a very brief comment for your benefit and what I'm trying to accomplish here. Amendment 1, and you all know what First Amendment is when we say our First Amendment rights, but let's read it. Congress shall make no law. That means they cannot make any law respecting an establishment of religion. They can't make Catholicism the religion of the country, or prohibiting the free exercise thereof. They can't restrict a religion, or abridge the freedom of speech, or of the press, or the right of people to peaceably to assemble, and to petition the government for redress of grievances. Now, as Supreme Court case law has come out over the years, is you see infringement upon those rights. For example, they pass laws that along the angles that affect some of these things with us. We are engaged in a huge battle right now because all of the censorship that is going on relative to social media, what the courts are saying is they are saying that's not the government censoring you and affecting your free speech. That is a company. But as we now know, there has been, in my opinion, the slipping away of where does the government ends and where does the social media companies begin. But that's what the First Amendment says. Now, the Second Amendment, another amendment that all of you are familiar with and you fight for all you can all the time. A well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, there have been, under Supreme Court law and through the legislature, what happens is the legislature, Congress, will pass laws, states will pass laws, and somebody will challenge their constitutionality under the Second Amendment, and then there will be tested to whether or not they in fact actually do that, or are there a reasonable and necessary exercise of the government power, and whether or not they, according to constitutional standards, that they're okay. Now, one thing, or a couple things I want to stress here. A well-regulated militia being necessary for the security of the free state. You know, militias are allowed in this country. But of course, they get attacked. It's so funny that some of the exact same things that went on in 1775 and earlier, leading up to the American Revolution, which really began in 1775. People forget that. It began before 1776, the Declaration of Independence. Lexington and Concord had already happened. Is the fact that some of these things that we had before then, they mess with now. In other words, speaking out against our government for infringing upon our liberties, they come after you. Well, that's something that's, you know, we need to always make sure that we protect, is our right to speak up against our government. The right of the people to keep and bear arms shall not be infringed. Well, they have infringed upon our rights over and over again, have they not? And you've had Supreme Courts uphold those infringements. And sometimes they knock them down. But that battle goes on every day. By the way, there was recently, I think it was a Saturday night, a little gathering of gun rights folks. You know, one of the things that bothers me about some groups is they state the obvious. And what I mean by that is this. I am 1,000% gun rights. But I just want you to know, who in the state of Kentucky, when you think about it, doesn't recognize that we do not have the Second Amendment? I guess the issue becomes in some of the details. There are people, for example, that want to go all the way back prior to federal law that was passed in the 1930s that restricted guns' rights. I can tell you this, in my personal opinion, on gun rights, I'm not for red flag laws. I'm one of those people that think bad guys are going to get guns. We shouldn't infringe on the good guys getting guns, whatever type of guns and everything they might be. For example, there's lots of restrictions on silencers. There's restrictions on bump stocks and all of those. Well, we all know the bad guys get them, right? All right, Amendment 3. Note this was the Quartering Act, which was a big factor in the American Revolution, is when the British housed soldiers in the homes of the colonialists. No soldier shall in time of peace be quartered in any house with the consent of the owner, nor in time of war, but in a manner prescribed by law. Not really of an issue, but could it become an issue? Absolutely. Amendment 4. Now we're going to get into the amendments that are really involved in criminal prosecutions. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. That has stuck with us since day one, isn't it? Probable cause for that warrant. Supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. You got to be very specific. And that, of course, leads to all of these battles of whether or not a warrant was necessary or not. We have exceptions to that. For example, the heated, you're following a crook, a criminal, in a heated chase into his home. You're allowed to follow exigent circumstances, they call it. Then you have seizures of things that you wouldn't have otherwise gotten except for a bad warrant, therefore, or no warrant, and it's called the fruit of the poison tree. So therefore, that's not admissible. But the Amendment 4 is very important. Now just think about this. And I believe that the Founding Fathers put these in the orders of importance. Amendment 1, man, religion, right to gather, free speech. Amendment 2, right to bear arms. You see, they really did, in my opinion, prioritize these. Amendment 5, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. By the way, felonies in this country, both federal and state felonies, remember we have a dual system. state system, federal system. And guess what? Each state has its own constitution as well. You have all these same rights under your state constitution in Kentucky and Ohio, as well as the federal constitution. Most of them are mimicked. They're copied. They're mirror images of them. But guess what? For a felony, they have to take you to the grand jury, what they do called a direct indictment. Jury in cases arising in the land or naval forces or in the militia when in actual service in time or war in public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Double jeopardy. If you're found not guilty of the exact same crime, they can't charge you again even if you admit you did it. Nor shall be compelled in any criminal case to be a witness against himself. It's why we call it plead the fifth. You do not have to testify in a criminal matter on yourself. Nor be deprived of life, liberty, or property without due process of law. You talk about lots of Supreme Court case decisions of defining what that deprivation is. Nor shall private property be taken for public use without just compensation. So, the federal government, state governments can take your property. They just have to pay you for it. That's what that means. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy trial and public trial. Now, I want to tell you about that. That's very interesting in it. You get to this, it becomes an interpretation of what exactly is a speedy trial. And you can waive your speedy trial. They ask you a lot of times to waive your speedy trial as they investigate. Or they'll just go charge and have a trial too quick for you. By an impartial jury of the state and district wherein the crime shall have been committed. You have to be charged where you committed the crime, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. That's where you see in the arraignment, what does the judge do? He tells you what you're charged with so you can enter a plea. To be confronted with the witnesses against him. Very important. You have the right to cross-examine your accusers. There is no bigger obtainer of the truth than cross-examination. I tell stories all the time. You can sit in a courtroom and hear somebody testify, and you think, pretty good. After cross-examination, you're like, wow. Change your mind 180 degrees. To have compulsory process for obtaining witnesses in his favor, which means you have the right to subpoena people to show up, and to have the assistance of counsel for his defense. Not a bad setup, is it? You know, look at the most wonderful system that our founding fathers set up. And remember, it was all based on a simple concept. Our founding fathers would rather one guilty person go free than one innocent person be convicted. That is the spirit of all of this. Doesn't work out always, but that's the way it is. Now, Amendment 7, everybody forgets about, especially the constitutional conservative right-wingers who are tough on crime and First Amendment and Second Amendment. Well, you never hear these people talk about Amendment number 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This means you have a right to a jury trial when you have these disputes with money, personal injury, medical malpractice, disputes with your neighbors relative to property, so forth and so on. You know what? Everybody wants to fight for all the... You know what? The Seventh Amendment gets forgotten. For example, you can't make this up. We found out that in case law in the Durrani trials, we use this to argue that there's a right to a speedy trial in a civil case. Makes sense, doesn't it? You have a right to a speedy trial in a criminal case, not necessarily in a civil case. How messed up is that? Amendment number 8. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. By the way, many times the death penalty has been shot down under that clause, cruel and unusual punishments. Bail, you've seen all those battles at bail. Ohio just went through this when they were trying to basically not require bail or have any bail. You got to have bail. Bail's very, very important for obvious reasons. And you always have what's called bail reduction hearings. Amendment number 9. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What that means is that despite the Constitution, there are rights that the people have in their states, and nothing on this Constitution should infringe upon those. Now, this is the biggie as it relates to state rights. Amendment number 10. The powers not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states, respectively, or to the people. So, there you have it. If there's not something spelled out in the Constitution, it's supposed to stay with the individuals and the states. And there's been obviously lots of battles over that. Amendment number 11. This was ratified in 1795. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. What they're arguing here is that the judicial power of the United States, Article 3 judges, now not extend to any lawsuits against one of the United States by citizens of another state. In other words, states can sue a state, citizens can sue a state, and they're not necessarily under the realm of the Constitution. Amendment number 12. This was ratified in 1804. I believe the same day, the same year as the 1804, 1805, the Louisiana Purchase took place. This had to do with the electors of how we elect the president and the vice president and whatnot. No personally constitutionally eligible for the office shall be eligible without a vice president of the United States. Choosing the president, the vote shall be taken by states. I mean, it deals with the election of the president. I'm not going to get any more details of that because it'll slow us down on our little journey here. It's a very long paragraph. Amendment 13. This was big. Ratified December 6, 1865, before Abraham Lincoln was assassinated. Remember that movie Lincoln? They focused on this. Neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to the jurisdiction. This is where we ended slavery. Remember, this is a weird thing. The Emancipation Proclamation of Abraham Lincoln, what it did was free the slaves in the slave states. People forget about that. It was just an executive order. What this did is it made it law, ratified by the states, and eliminated slavery, period, in 1865. Congress shall have power to enforce this article by appropriate legislation. Then we have the 14th Amendment. A lot more law going here. This was ratified in 1868. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States where they reside. That makes you a citizen. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within this jurisdiction the equal protection of the laws. You hear that phrase all the time, the equal protection of the laws. You cannot pass a law that treats me and this person over here differently. Now, there becomes, under Supreme Court cases, lots of exceptions. And there's all these constitutional tests to see whether or not it violates the Equal Protection Clause. But that's the infamous Equal Protection Clause. Then Section 2 lays out how many members of Congress, how you elect members of the legislature. Let me see. Section 3, the senators. Section 4, the validity of the public debt. Section 5, Congress shall have the power to enforce. Section 4, let's read this. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave. But for all such debts, obligations, and claims shall be held illegal and void. All right, amendment number 15. The rights of the citizens of the United States to vote, ratified in 1870, shall not be denied by race, color, or previous condition. So, Amendment 13, no slavery. 15, the right for blacks to vote. Amendment number 16, ratified 1913. Congress shall have the power to lay and collect taxes on incomes from whatever source derived, without apportionment among the several states. Think about that. Congress shall have the power to lay and collect taxes on income. You know what that is? Yep, you guessed it. The income tax. Amendment number 17, ratified in 1913. The Senate of the United States shall be composed of 2 senators elected by the people for 6 years. Each senator shall have 1 vote. What happened here is this took away the election of the United States senators from the state legislatures. It used to be that each state legislature elected the senators. Amendment number 18, passed in 1919, repealed by Amendment 21. After 1 year of ratification of this article, the manufacture, sale, or transportation of intoxicating liquors within the importation or exportation is hereby prohibited. What was this? This was the Prohibition Act. This made the manufacture, sale, or transportation of intoxication liquors, import or export in the United States, illegal. And what happened after that? Lots of gang warfare. The creation of the mafia, right? It would later be repealed. Amendment number 19, ratified in 1920. The rights of the citizens of the United States to vote shall not be denied or abridged by the United States by any state on account of sex. This was the right of women vote. Women's suffrage finally made it in 1920. So let me see. You ladies went from 1787 to 1920 without the right to vote. Sorry, wasn't my fault. And then we have the 20th Amendment, ratified in 1933. The terms of the president and vice president shall end at the noon on January 20th. Congress shall assemble at least once every year. Man, they stay in symbol, don't they? Section 3, fix the term of the president, vice president. They talk about the death of the House of Representatives. A lot of constitutional legislation, a lot of Congress in there. Amendment number 21. The 18th article is hereby repealed. How do you like that? The repealing. This is the only amendment to repeal an amendment. It didn't work out, folks. Amendment 22. No person shall be elected to the office of the president more than twice. Ratified in 1951. Remember, Grover Cleveland had a term in between, but he's allowed to do that. FDR is the only president that chose to be president. He was elected 4 times, folks. He served 3 full terms and then died right after getting elected, his 4th term. Only president to ever do that. Article 23, Amendment 23. The district constituting the seat of the government of the United States shall appoint in such manner as Congress may direct. The number of electors of president and vice president. Again, more electing of the president and Congress. Amendment 24. The right of the citizens of the United States to vote in any primary or election for president or vice president or electors shall not be denied. Article 25. In case of the removal of the president from office or his death, the vice president shall become president. Ratified 1967. Isn't that interesting? It wasn't really clear how that was supposed to work. This made it official. Their vacancy of the office of vice president, the president shall nominate. Remember, that's what Gerald Ford did. Let me see. Amendment 26. The right of the citizens of the United States who are 18 years of older shall not be denied or abridged or by any state on account of age. That made the infamous 18. You're legal. That was ratified in 71. And in 1992, Article 27, Amendment 27, no law varying the compensation for the services of the senators and representatives shall take effect until election of the representatives shall have been intervened. So there you have it, folks. The Constitution and the Bill of Rights. It's still the best we got. But the battles over all the edges shall always rage on. I stand with liberty. I shall defend the Constitution and the Bill of Rights to my death.